I'm going to persist with giving welcome to country in Noongar language, and I recognise the ironies of that to some extent, in that for many years it was not even legal for Noongar people to speak their language, and so for me as a Wodjila or white person speaking Noongar language, I fully appreciate, in a sense, the ironies. Nala kadich Noongar mort, kan kadich nidja puja, nan kadich Noongar wajja, kabli, burn, kuriye. And we are in the Noongar season of Camberang. There are 6 Noongar seasons here in Boorloo or Perth, and Camberang is the transition season into the hotter months, which we're obviously approaching right now. So the topic for today is, of course, whether or not artificial intelligence can be an inventor. We can ask that question in a specific sense with reference to the Patent Act and the Federal Court case of Thaler, but I guess we could also ask that question from a more philosophical and perhaps even existential point of view, and perhaps we'll touch upon both those sorts of themes as we go through today. So the plan was to hand the mic over to Professor Joshua Fairfield, who's going to give a 30-minute overview of this topic of whether artificial intelligence can be an inventor. I then plan to hand the microphone over to the Information Commissioner to provide some reflections both on what Joshua has said, but also perhaps even drawing upon the event last Thursday, because to some extent the themes of artificial intelligence were integrated into that event, and there were some interesting observations throughout. And then I plan to open it up to the floor and to field questions and comments in relation to this topic, and perhaps at the end to think about where to from here. We purposefully made this a relatively intimate event on the basis that we might use it as a springboard for further activities next year. But of course that depends partially on where the discussion goes and the level of interest. So look, there's lots I could say about Professor Joshua Fairfield. He's someone that's been in the law and tech space for a long time. I believe that you had some involvement with Second Life and the law of Second Life, which actually was a bit of a blast from my past when I was thinking about Second Life, which I did enjoy playing around with about 10 or 15 or 20 years ago, however long it was now. But obviously the law and tech space has become more and more important, more and more influential, and perhaps we could say that there's probably never been a time in history where it's been more important. But one thing I would say about law and technology is, although we think of it in contemporary terms, there's nothing particularly new about law and technology, in the sense that if we think about a fence, or if we think about a door lock, these types of technologies have always existed alongside property law for many hundreds of years, if not millennia. So obviously tech keeps changing, but the actual concept of technology is obviously not new, and we could of course reflect upon First Nations peoples and the 60,000 years of history in this country to also reflect upon technology. And we might think about the 1 million petroglyphs at the Burrup Peninsula, which is a 20-kilometre peninsula with 1 million petroglyphs there, many of which have been there for thousands and thousands of years. And we could think about that through a technology lens if we chose to do so. So without further ado, I'll hand it over to you, Joshua, and then, as I said, the Information Commissioner.
Thank you so much, Dean Cunningham and Commissioner Fletcher. And thanks also to Dr. Koutras, who I have a long-standing relationship with. I was on a sabbatical in Bonn in 2013, and we ran into each other at the University of Corfu when I was working on law and technology questions related to my first book. And then many of these thoughts are based on a book chapter that we've contributed together. Also, thank you to Pnina Levine and Serena Arghezi, both who I understand helped enormously in organizing this event. I'm an appellate lawyer, so I'm going to turn on a timer here. And apparently when the light turns red, I stop speaking. But in the meantime, I do hope that this can be informal. I hope above all to be clear enough to be wrong. And if there's something that you'd like clarified or you want to engage, the studies show that after about 7 minutes of listening to the same person's voice, your brain turns off. And so I've got about 5 minutes to go. If there is something that you think of in the middle of this, please just interject, pile right in, and let's have a back and forth about it. It'd be far better than me going on for half an hour, and then we can listen to the snores at the end of it. The question of can AI be an inventor? I hope to dispose of that question fairly quickly and not by answering it. To do that, I'll start with my favorite quote from cyberneticist and physicist Edsger Dijkstra, who said in relation to artificial intelligence, the question of whether a machine can think is no more interesting than that of whether a submarine can swim. You might ask yourself, if you receive a love letter and then learn that it was composed by AI, how would you feel about it? If you receive in many ways, science is our love letter to the human species. And what I'm going to talk about are the problems of moving from human-machine science to machine-human science. Worldwide, the Thaler case has largely yielded the same result. There's been, of course, Justice Beach here in Australia, and his opinion, which raised some serious contemplation, and there was sort of a moment in South Africa, which raised a similar question, and those are largely definitional questions. Can AI meet the legal definition of an inventor? And the answer is one of semantics, as is all of law, but not when we look at why we choose to engage in intellectual property law at all. Just like a love letter written by artificial intelligence, just like an Olympic swimming event won by a submarine, there's something fundamentally wrong with the question of whether or not an AI can be an inventor. Among other things, it's easy to see that there's something wrong with the question because any way you answer it, you're left thinking there's something off. If the answer is yes, something badly wrong has happened here, where AI doesn't need to eat. AI doesn't need a state-granted monopoly on an idea any more than sand does, any more than the wind does. And so we ought to feel profoundly awed by granting a state-granted monopoly, which is intended to secure the ability to eat, the ability to get a roof over the head of a human being with needs of food, calories, shelter as inputs to a system that generates as outputs ideas that benefit all of us. That entire system is just a bad fit, just like dunking a submarine into the end of an Olympic-sized swimming pool. Something's gone wrong. Similarly, if you answer the question no, you run into two deeply problematic facts. The first is, well, how do we deal with rewarding companies that come up with something that has enormous value? Second, how do we begin to deal with the fact that those companies have expropriated the work of billions of humans in training their artificial intelligence? We've been down this path twice before, and each time we have screwed it up. We thought the internet was going to cause a flourishing of democracy worldwide. That did not happen. And instead we got the business model of surveillance capitalism. We thought that social media circa 2010 was going to cause us to connect with each other, and we were left with the profound alienation of the COVID era. If these social media systems had worked to unite us, we would never be closer to each other, and I think anyone who's got access to a television can say that's not true. And so we're at the third branch of this. We're seeking to regulate it at the beginning, and we should, because the emergent business models of surveillance capitalism and mass internet disinformation have hurt us badly times 1 and 2. But it doesn't mean that we know or have any idea what the business model is going to look like at the end. And so if we say no, AI can't be rewarded, or the companies that create AI or train AI can't be rewarded in some way for the creations, we're left with them scrambling for a business model. And as Google's famously mocked motto, "Don't be evil," can demonstrate with the rise of surveillance capitalism, emergent business models can really come back to bite us. So the answer is both yes and no, and it means that with any scientific question, that means we've asked the wrong question. It means we need to unask the question. So then, what's the right question? Well, the discussions around AI are notoriously apocalyptic. And I think that one of the big problems here is that we're talking about the wrong apocalypse. So I'm going to talk about 3 apocalypses, one of which I think we can quickly dispose of, actually. I'll talk about Judgment Day. Now, Judgment Day is the name of a title of a Terminator movie. And there the idea is that the toasters will rise up. That the refrigerators will come to deplore us, their prior creators, and will assert hegemony over us. In a way that maybe reflects our own sense of guilt that over our responsibility to our technological progeny, that may reflect a legacy of colonialism. That's not what's going to happen. The threat of artificial intelligence is not that the toasters will rise up. It is that it will become competent to our tasks and indifferent to our welfare. That it won't care because we didn't care, and it learns from the best. When it learns through neural nets, now I'm talking about the process of training artificial intelligence on billions of exemplars of human action. That problem, that it will be competent to our tasks and indifferent to our welfare, leads to the real apocalypse. The real apocalypse, the near-term apocalypse, is going to be economic. That is, economics, and presently our inability to address our economics, is why we can't have nice things. There is no question that this technology is going to blow the wheels off when it comes to invention, when it comes to art, when it comes to my students drafting relatively coherent legal briefs. It's going to change a lot. But the thing that it's going to change most of all is the clear inability of our system of laws to distribute the output of our society. There's no question. Under our society, there are 2 ways of earning food and having a roof. You own things or you work. The working end of the equation has been under significant pressure for some time, and this technology is going to absolutely kick the foundation out from underneath that way of earning a living. I'm not saying we shouldn't use it. I'm not saying it's not going to be as revolutionary. I was on the phone with one of my students who's a practitioner in New York saying, look, this is bigger than the internet, and it is bigger than the internet. But one thing is, the failure is primarily not technological. The failure is overwhelmingly economic. It is our inability to envision a future in which we can distribute what this is going to do in a way that continues to feed and shelter humans. Now that leads me to a third Judgment Day. And this is a story that it's a science fiction story out of the 1950s, written by science fiction author L. Spragdicam, named Judgment Day, which I thought was particularly appropriate given the reference to the Terminator. And it's a very different Judgment Day. In that story, what's going on is that there's a very alienated scientist who is trying to decide what to do. The scientist has a simple decision: whether or not to publish a research paper. Because what he's found is that there's a way of fusing iron, which if used would set up, this is not real science, which if used would set off a chain reaction and could be easily weaponized, could blow the crust off of the Earth. But his entire point is just simply, should he publish the paper? Because if he publishes the paper, he knows very well it's the end of the species. He knows at some point, someone, somewhere will be desperate enough to use it. And so he knows we're done. If he publishes it, we're done. And if he doesn't, if he withholds this, there's at least a chance that we as a species continue. Now, I'll leave you in some suspense as to what the scientist chooses. But what I want to say about our technology is this. Until now, science has been a human endeavor. Not the what of science. If you think of the core question of science, the falsification test that we're also used to, right? We pose a question in the negative, and then we look for evidence to falsify that null hypothesis. That's not actually why we do science, that's how. There is nothing scientific at all about the selection of questions that we choose to study. There's an infinite array of negative facts to prove using the scientific method in this room. There's an infinite array of negative facts. We could prove that this glass is not there, it's not there, it's not there, it's not there. We could do that all month long. We don't choose to do that because it is not of human interest. It is not rooted in our welfare. Now, in my lifetime, how we have done science has changed already once radically. When I was going through university, and many of you in the room may remember this, the idea was you were supposed to pose a hypothesis and then look for evidence one way or another to prove or disprove it. Science radically changed already by the time we hit 2010, because what we did was, the whole idea when I was going through university was the data-driven hypotheses, simply starting with the data and seeing what patterns are there, was considered bad science. Now it's the only way we do science. It's a different kind of science. Now I'm just using that as an example. Still human-driven because we still select what patterns in the data are interesting to humans. But we're about to come to another phase. We're about to move from human-machine science, that is, humans select questions, tell computers to go forth and detect patterns in colossal data sets, to machine-human science, or perhaps predominantly machine science. The selection of research questions, the things that we choose to do and why, will no longer be subject to human scrutiny. Rather, the outcome of this process of AI-generated science will be fundamentally inhuman. It will choose questions we have not thought to ask, and that will bring amazing benefits. Make no mistake, there will be questions that we did not think to ask that have answers that are already recorded in our actions and in our speech. And when we turn on the massive, colossal tape recorder of billions of exemplars of human voices and human experiments, and we turn that loose on itself, it is going to uncover things that we knew but we didn't think we knew. Things like unearthing scientific knowledge from thousands of years of petroglyphs. It will do that, there is no question, and that will unearth solutions that we haven't even begun to think of for problems we haven't anticipated yet. But there is a difficulty here, which is the superpower of the human species. Our ability to solve the problems of the future involves doing what we're doing right now. It involves speaking to each other, trying to create new normative worlds of meaning. We don't have to evolve in geological time, in historical time, to solve new problems. We do science. We propose new problems. Technology, in the words of Stanislaw Lem, is the domain of problems posed and their solutions. So how do we solve the problems of the future? We talk about it. We use our human superpowers. One popularizer puts it, bees and ants can't declare a revolution, declare the monarchy over, and declare a republic. That's what we do. We do that. Our ability to create new worlds of meaning is swimming. The replication by rote of the massive set of tape recorders that are large language models or artificial intelligence that searches through a colossal data set for new inventions, or with inhuman patience simply sorts through infinite chemical compositions to find a new chemical composition, is not. And there's something strange that happens. The AI, in many senses, is reliant upon our voices in actual legitimate conversation with each other to ground itself. It's a simple experiment. Plug a large language model back into a large language model. Make it talk to itself and watch it go insane. It will. It will rapidly lose the grounding in meaning that makes any of this make sense. Plug inhuman science into inhuman science and you will discover profoundly inhuman science. Our science should keep us alive. That is not a test of falsifiability. It is a test of human viability. It is a test of human thriving. We have picked the research questions that humans pick because they resonate with us as humans. We should be prepared for insights that are profoundly not ours, for scientific insights poured back into scientific insights that not only yield true statements that we haven't thought of, but that yield profoundly false or at least alien systems of power that we have nothing to do with. This matters. Why we do science is of profound importance. Here I'll rely on the work of Jean-François Lyotard, a Canadian philosopher of language and information, who pointed out something very interesting. He said technology is never neutral. It's not a matter of technology is neutral and humans then use it in one way or another. Technology is designed, it is produced out of a social context. It is shaped by that context. It is no accident that our science is the way it is because it is predominantly produced in corporate research labs. For good and for ill. It is simply a fact of it. It is our power policy worldwide, said Jean-François Lyotard, because he was working with earlier technologies. He said, look, it matters that nuclear technology was developed as a weapon. Had it been developed differently, we would have a profoundly different relationship with it. It's essentially a hack in physics that could have generated enormous energy for the species. We have a very, very different reaction to it across the world because of the context in which it was generated. Why we do science matters, and for AI-driven science, there is no why. I can't state that strongly enough. There is no discernible why. Once you are 25 levels down a decision tree in a neural network, the one demand we cannot make of artificial intelligence is transparency. The one demand we are absolutely incapable of making is asking it why. We can look at the training data if we want, and that's been the European approach to try to constrain this stuff, is give us the training data. But that doesn't work. That just simply is a way of protecting existing intellectual property by saying stop feeding it artists' specific indication, or stop feeding it the methods of individual scientists because it's going to replicate an art style, or it's going to replicate the work of a given scientist's methodology, or it's going to practice a patent and hide the fact that it's practicing the patent. Fine, that's just a way of protecting existing human intellectual property relationships and human endeavor. But it doesn't provide any transparency. No one knows why a neural net reaches the conclusion it does. We simply know what data we've fed it, and we know how eerily accurately we've chosen to tune it against its outcome data. Given that we are now in the middle of transitions from human machine science to what I will optimistically call machine-human science, and the reason that I optimistically call it machine-human science is because there is still a role for human in that sentence. We are going to have to take several steps. The first is we're going to have to stop asking, can AI be an inventor? Can AI be an author? Can AI compose music? Just like we have to stop asking, can a submarine swim? Should we give it the gold medal at the Olympics? It's an incoherent question. It invokes a series of economic and science and philosophy of science problems that are far too deep for our guild, for my guild, lawyers, to be trusted with the answer. Among other things, if you trust my guild, lawyers, with the answer, we will do things like ask whether or not the word inventor seems to fit this rule. We'll say, well, gee, it seems to have been sourced by this program, and we envision inventions coming and sourced by individual humans. That's a fiction already, right? Every invention ever made stands on the shoulders of giants. Every scientific invention that's mattered in the 21st century is made by teams now. I saw a post on Reddit asking recently, why aren't there famous scientists anymore, like Albert Einstein? And one answer is because science is now done by groups of 40 and 50 people, the science that's worth doing, and it's being done by tool sets that are parsing through the individual contributions of billions of people. We're doing it differently. In doing it differently, we're going to have to stop asking questions that try to fit this square peg in this round hole. And we're going to have to go back and say, as Dean Cunningham did in the beginning, what are the legal principles that do stand the test of time? There is, in fact, nothing new here. We have developed tools, time out of mind, that have made human work easier. We have created systems of leverage and industrialization of effort, and we are now doing the same for mental processes that we did for physical processes. We did a quite bad job of dealing with industrialization, but the species continued at least for another 100 years. And we're going to have to buy ourselves some time to do the same for the automation of mental processes. Now, we have lots of rules for doing that. Let me make all of this abstract stuff quite concrete. I predict with very near absolute certainty that the output of these questions will not be that worldwide AI will be an inventor. Rather, I strongly predict that the companies that have developed AI and their shareholders will reap the productivity gains generated by them. That almost none of those productivity gains will go to humans who need to eat and need roofs over their heads. That's my second apocalypse. And anybody who wants to bet that that won't be the case, you can come be my retirement fund, because I'll bet you any amount that you care to name. Now, what we're going to have to do to stop that future is go back to the drawing board and find a way of applying the systems of law that we know already. Law, like science, is a love poem to the human species. It is our language of how to live together, of how to cooperate and how to thrive. And any language, any legal language that doesn't lead to human thriving has no purpose being in the law at all. We've lost sight of this because of the hegemony of corporations and their intellectual property holdings. But the whole point of it was to secure human effort. The whole point of this was to benefit humans. And somewhere along the line, worldwide, we've lost the plot. We've lost the plot by asking the question, not by answering it in the negative. And I presume we will continue to answer it in the negative, but we're not going to answer the real question in the negative. What's going to happen is, as is already happening, these companies will assert copyright interests in the code of the interface programs, not the AIs themselves, because they are trained on massive data sets that, except in the EU, are generally not protectable under copyright law. They will then use end-user license agreements. Go read them. Go read the ChatGPT license agreement. Go read the Stable Diffusion, Midjourney license agreements. They will use those license agreements in the same way that Facebook, or whatever the hell they're calling it these days, used its end-user license agreement to expropriate what was not theirs. To say, if you use Facebook, we get all of your personal data, and we will simply extend that. If you use Midjourney, we get, and it's there, go look at the end-user license agreement, we get a fully paid, non-exclusive, universal license to use whatever you generate with Midjourney, and whoever is trying to come up with an AI inventor will come up with the same kind of licensing schematic for whatever the AI comes up with as a matter of invention. And that is simply what is going to happen. We are going to leverage thin and, frankly, wildly questionable from the end of the 20th century copyright policy. Thin and wildly questionable copyright will translate into absolute ownership interests in the output of these systems. There is a bug in law when we are thinking about things that way. That's what's going to happen. Now, what do we do about it? Well, we're going to have to go back to the systems that work and why. The first chess programs, we tried to teach to play chess by teaching them the rules of chess. Those programs failed, to put it mildly, just like the first programs that we tried to teach French by teaching it the rules of French did not make it. What did we do? We then fed in every chess game ever played at a professional level into an automated system, and we had it learn from that. And we also, by the way, fed in colossal numbers of exemplars of the French language. into, or the English language. It was the Enron emails. By the way, if you think we're training AI to take care of us, remember, large language models originally were trained on emails produced by one of the largest moral hazards, the largest moral frauds of the 20th century. We're training them on colossal numbers of human speech, and then the whole point is that it just simply asks, statistically speaking, what word is likely to come next, what invention is likely to come next, what brushstroke, what technique in art is likely to follow based on the trillion, what chess move is likely to come next based on billions of human exemplars. So we train it from all of us. And those programs then defeated the best chess players. But it didn't stop there. These programs do get lost. Plug a large language model into a large language model. You can do it. It's really interesting to watch. It does go insane without us to ground it. The best chess teams do now occupy this middle space. Humans curate, guide, provide context to AI decision-making in a way that shapes and trains its results. We are the ones determining the number of waiting points, for example, in a decision tree to train a neural network. We still decide that. And when it gets stuck, or when it is overtrained by memorizing its own data, and so it becomes a circularity problem because now it's perfectly memorized its own data and therefore has no predictability whatsoever, we're the ones that develop statistical techniques to shake it loose from that. Things like n-fold validation, where you test it, you train it on some portion of the data, hide another portion of the data from it, and then test it on the portion of the data that you've hidden from it. It's a very basic technique, but it solves problems of overtraining, which otherwise means that the AI model is perfectly capable of memorizing every piece of data you give it to it, and then every input matches perfectly to every output, and it's useless for prediction. This model of human curation, of machine-human science, is where we need to end up. One initiative that I have found quite interesting from the European Union has been the requirement of a human in the loop with respect to artificial intelligence. If your loan is denied, there needs to be a human whose responsibility is to articulate why. There needs to be responsibility, liability, may I even say as a lawyer. There need to be points of access for human explainability, for human responsibility, to hold companies, to hold businesses, to hold individuals accountable for the output of the products that they create. Never mind that the output, the beneficial output, needs to clearly be distributed, but also the damaging output needs to be managed. And a human in the loop is a standard model for these kinds of arrangements. I think that is one edge of a set of innovation that could make machine-human science less of a machine plugged into a machine and that circularity which creates problems. By the way, if you want to observe this circularity, you might ask yourself, one reason why online discourse has gotten crazier and crazier of late is because a non-trivial part of it is artificially generated. And the algorithms are taking their own outputs now as inputs. Right? The snake is devouring its own tail, is cycling and spiraling further and further. And that's one, among many other reasons. I'm not saying that's the only reason why, Reddit is insane. I'm saying that is a reason why Reddit is insane. Or Twitter, or whatever Musk is calling it this week. These kinds of efforts to return us to machine-human civilization reflect our last obligation. And this is where I'll end since I'm an appellate lawyer and I've got 57 seconds. There is no such thing as a mathematical model that is more predictive than the phenomenon itself. We can model the ocean, but it's never more accurate than the ocean. We can model the tides, but it's never more accurate than the tides. We can model what humans need to thrive, the norms that we need to generate in order to survive into the next century and to thrive as a species, but no model or predictive entity of that is more accurate than us ourselves. We are our own barometer. And the norms that we generate, what we want and need to live, that is the role, the selection, to bring it full circle. Got 10 seconds. the selection of scientific questions, the future that we want to build, cannot be left to machine-human science. And there's my time.
Well, a tour de force, amazing, and a real polymath interpretation of where we've been and where we might be going. I just wish that you'd told me that we got the wrong question before. I came up with another one during your speech, which is, should we give an Australian nuclear submarine purchased from the United States of America a gold medal at the 2036 Olympics? So maybe that might be the next forum. I won't try and summarise, but I did invite the Information Commissioner to respond because I thought she'd do a much better job than I ever could in relation to a tour de force like that. But I will just point out a few quotes or concepts that were traversed along the way in order to give the Commissioner some time to compose her thoughts. The first is this idea of science as a love letter of the human species, which I thought really spoke to me. That bumped up against surveillance capitalism, which is perhaps not the love letter that we might hope. You then talked about various scenarios relating to Judgment Day. And this idea that AI might be competent to a task but indifference to welfare. And I think that is a really important concept. You also mentioned that the AI might be bigger than the internet. And I'm not sure if anyone's seen IT Crowd where Jen actually does a presentation on the internet, which is a little black box. Made me think of that. But you then went on to essentially talk about Popper's falsification theory and the way in which science develops, thinking just as much about the process as the substance. And I guess from 2010 onwards, perhaps we've moved into a sort of Thomas Kuhn type moment of science where we are no longer relying upon pure falsification, but we are rather making leaps and bounds, but where to, we don't always seem to know. And you also mentioned the collaborative nature of science, but perhaps more importantly, the commerciality of it and the way in which commerce ends up becoming or driving both the science that we do, but also the outcomes that are forthcoming. You talked about the superpower of human species, and I guess along the way there was an implication that there's something special about humans to some extent, because you contrasted humans with bees and ants and indicated that that perhaps it's we as human beings that have the option of having a revolution, for example, a political revolution. And it made me think a little bit about Kropotkin and his book on mutual aid, A Factor of Evolution, where he talks about the fact that in fact, when you look at nature, cooperation is a much more powerful driver than competition, as a matter of fact. And bees and ants are actually a very good exemplars of that cooperative that cooperative tendency of nature, although we often tend to focus on the competitive dimensions. We're much more interested in the shark eating the human being than the ants and the bees burrowing away and producing and cooperating as they do. Predicting the future is always a hazardous task, but you did make some predictions, and one prediction was that companies will essentially reap the productivity gains of AI. And certainly from my point of view, that's a pretty sound prediction. You also alluded to my favourite game, chess. But in that context, what I understood you to say was that the machine is still relying to some extent upon the creativity and the analytical powers of the human being, in the sense that all of the data sets are generally fed from human activity, but where things might go haywire is where the machine itself starts feeding in the inputs, and then you've got the input-output problem that you alluded to. So with all of those reference points, I'll now hand it over to the Commissioner to reflect upon your tour de force.
Thank you, Robert. That's a big challenge. And thank you, Joshua, for a very erudite and, as Robert said, it's a very polymath view of things, and I'm not sure that I can quite do that task, but I will do my best to deal with some of the issues that I think come out of what you've said. And of course, you've learned that I'm the Information Commissioner of Western Australia. Just maybe just give you a very quick insight into the responsibilities that I have in Western Australia are to review decisions made by government agencies in regards to applications for access to government or government-held information. That's my primary responsibility, and there are subsidiary responsibilities around educating the public sector about what that means and educating the public about what that means, both in terms of responsibilities for the sector and rights for the public. But I take a broader interest in these issues beyond my immediate role, and my role does also bring into perspective issues around the protection of personal information, because that is, as you would imagine, an area that occupies a lot of our time. There is a right to have government-held information, but it's qualified in a sense in Western Australia. It's not absolute, as you would expect with most rights. There's some conditions upon it, so it's subject to the exceptions and exemptions in the Act. But the issue around government-held information is a really critical one in relation to the volume of personal information in particular that government holds, and I'll come back to that in a moment, because I think that's really going to be one of the big challenges for government's use of AI. Look, Robert's picked up some of the some beautiful phrases I love that you used. I loved I didn't love the phrase because it worries me greatly, being about AI being competent to our task but indifferent to our welfare, and I think that is really encapsulates the real fear that a lot of us have about the use of AI. But there were some other things that you said which give me hope as well, because even though we have fears, we also, I think, can also draw upon a better understanding of this to give us hope, and that is about legal principles that can withstand the test of time, and that's essentially what we're asking is, how can we get to a point where we have principles that will deal with whatever the new technology is. Now, AI is currently the new technology. There may be something beyond AI, and I'm not quite sure what it is, because I don't think we even have enough to understand its potential. So I can't even think what comes after that. And of course, human in the loop, which is a well understood, used, commonly used phrase, which also gives me hope that the demand for having a human in the loop with AI is something that I think is we must continue to insist on, particularly where the technology or the end result is a decision that affects people. And we must always keep that end in mind about the whole point of the law is to prevent harm or provide fairness. And if we give over decision making to machines without a human in the loop, then we really risk unknown harm. And I think that's where we have to be very, very careful. We've had there wouldn't be a person in this room who hasn't heard of robo-debt. I'm sure Joshua's heard of robo-debt. I'm still getting my head around robo-debt, what happened there, but the absolute calamity of entrusting machine-assisted learning in that case, I don't think necessarily artificial intelligence, but machine-assisted learning without enough human intervention. So we have some very good case examples of the problems of entrusting machines with decisions that affect people's rights, their welfare, without intervening and ensuring that the end result is one that is fair and doesn't cause harm. There are two, I suppose, from that sort of basic description of my role, the two main areas, and I'm no patents lawyer or intellectual property lawyer. My main concerns, as I indicated, are access to government information, but also the protection of personal information. Now, Western Australia sadly does not yet have privacy laws. They're under development. It's one of two jurisdictions in Australia without privacy laws. We have a federal privacy law. Some of the state or subnationals jurisdictions have got a privacy law. All of them that have privacy are wrestling with the idea of how do we deal with the concept of artificial intelligence and its intersection with privacy laws. And I can tell you the problem there is down to how we've traditionally defined personal information. And personal information currently is, in most jurisdictions and most privacy laws, very similar to what we have in our Freedom of Information Act here. It means information or an opinion, whether true or not, and whether recorded in a material form or not, about an individual, whether living or dead, whose identity is apparent or can reasonably be ascertained from the information or opinion, or can be identified by reference to an identification number or an identifying particular, such as a fingerprint, retinal print, or body sample. Now this, I think the first part of that, whose identity is apparent or can reasonably be ascertained from the information or opinion, based on, I think, humans applying their skills and abilities and learnings as to how do you ascertain that identity. But when you put in machines and big data sets and combine big data sets, you've got a whole new level of ascertaining someone's identity. And that seems to be a huge challenge for privacy laws. And there's a review going on at the moment at the Commonwealth level to amend the privacy laws. And the government just recently provided its response to the review as to what it is looking at doing, how many recommendations it agreed to enact, those in principle that need further investigation, and those which it notes which probably won't be implemented straight away, or even for some time until there's a lot more consensus around those. But one of them seems to be that need to change the definition of personal information to give recognition to the fact that decisions in government that require, or decisions in industry that require the application of the privacy principles are more amenable to the possibilities of identification of people's personal information. So there's a real challenge there as to how they're going to modify the definition of personal information, which is to say very similar to what I just read out, in order to expand the protections. Otherwise, if we're relying upon human judgment, in essence, in terms of sort of ascertaining someone's personal, ascertaining their identity, then a lot of personal information is going to lose the protection. It's not going to be protected. So that's a real challenge, and it's a very urgent one, I think. So we've got that issue, a challenge to privacy laws. So I hope you'll agree with me that that's a really big issue. And the other one, of course, is the one you mentioned about transparency. And I haven't quite got my head around the idea yet about you can't ask artificial intelligence to be transparent. There's a big question mark in my mind about that. But the whole point of transparency needs to be understood. Why do we require transparency around, particularly when it's government, using information? Underlying it is this issue of trust. And artificial intelligence, doesn't, as I think of it, isn't about developing trust. It's about predicting future things. So that whole human quality of needing to trust one another, of trusting the decisions of government, it is motivated, by a very human need, and that's how I see it at the moment. So transparency and explainability, I think that's probably right, but I'm just going to park my judgment about, can you ask? I think you cannot demand transparency from AI. Perhaps that's a different idea about whether or not it can be asked about how transparent it is. Can it explain itself, perhaps? But I don't think you can demand from it. So perhaps you're right. But would you trust its explainability? And would you even be able to understand it if it explained it to you? But we must have some concept of understanding decisions that affect our welfare, where they come from. Because that's the whole point of the legal system, isn't it? And the right to challenge decisions that are made about us. And if we can't understand them, then we can't challenge them. So I think that's going to be really, really difficult in the environment where government starts to use AI. And the little bit of reading that I've done, I'm again no expert on this area, but the little bit of reading that I have done that is looking at proposals for regulating AI that are coming out of Europe. And of course, recently there was the Fletcher statement developed last week. They talk a lot about how our existing legal system may well have some of the answers. And I think, that's where I find some hope, that our existing legal system can be adapted. So, do we have the principles, or can we develop principles that will in fact stand the test of time, as Joshua was talking about earlier on, or do we need to create new AI regulatory frameworks, which I think are going to be very difficult. One thing I am encouraged about in terms of sort of the discussion that's happening at the international level is perhaps we need to be very cautious about where we permit the use of AI. And I think government is particularly, is the most critical sector, if you like, of asking that question of itself. Where can we allow AI to be used? And if we are going to allow it, to insist upon the human in the loop, so that decisions that affect people's welfare are not made indiscriminately or are not viewable. So I think they're in my world at the moment, they're the two big issues, or two areas of the law that I'm working with. No doubt, as you say, there are challenges in all sorts of areas. And it's not just adaptability and flexibility and fairness, but there are even more broader ethical issues beyond that, which I'm not an ethicist, but ethics, of course, underpins law, and I think we all have to embrace those discussions and get back to what are the fundamentals of law in order to remember what sort of protections we need to insist upon before we let this into the realm of government decision making. So I hope that expands a little bit upon perhaps what I think in response to your really, really interesting points of view, and welcome to hear some of the discussion around the room.
Thank you so much, Commissioner, and particularly the message of hope, I think, is a really important thing to hang on to in relation to this. And I often think, as academics and as educators, we do have a role to lament the dark, but equally we have a role to light candles as well, and to provide that role. And I think ideas and discussions are part of that story. The other theme that's emerging is this idea of legal principles standing the test of time. And, no doubt, Professor Fairfield, you'd be aware of Judge Easterbrook's notion of the law of the horse when describing cyber law back in the mid-90s, saying that, well, we can't come up with an area of law called cyber law because there's no, that if we think about the law of the horse, for instance, that became a sort of metaphor to think about, well, how are we going to apply old legal principles to new concepts? And I think, I guess that notion is something that we need to flesh out in the first instance, is rather than going and reinventing the wheel, what legal principles can we rely upon from history to help us in the past? And I know I often quote Winston Churchill, who said that the further you look into the past, the more likely you are to be able to see into the future. And I've certainly found it useful to look at Roman law principles, for example, in the context of intellectual property, and particularly contrasting ideas like res communis and res nullius, which really is about how you construct ownership and the emergence of property and who owns what, which, obviously from that question of who owns what comes important economic questions, which is who gets what. And property and contract law become very intertwined with capitalism, and particularly surveillance capitalism. Whether or not we can say that people are agreeing to privacy violations and other misinformation dynamics is probably cause for another discussion. But it's interesting to think about the word open in the context of ChatGPT, because of course it's not open in the way in which we understand it at all. It's very much driven by corporate interests. And if you take a lot of things, even Uber, for example, was a ride-sharing concept. It was essentially using technology to facilitate hitchhiking. But of course, it got monopolised and to a large extent monetised by Uber, and it's now used for corporate interests. But when you think about the concept as it emerged, it was about sharing resources. So if I was moving from A to B and someone else wanted to catch a ride, then, as I say, it essentially was developed as an advanced form of hitchhiking, but has become essentially another form of taxis in many ways. So the final theme that sort of come through really strongly is this human in the loop story, which I think is really useful. And I often say to students, ask yourself, what do you think the comparative advantage is of being a human being over technology? And obviously there are lots of ways that question could be answered, but from my point of view, chess is another good metaphor here because it involves blending the analytical with the creative. And whether or not AI can do that now or effectively in the future, I guess remains an open question. But that blending of creativity, because predicting the future based on what things that have happened in the past might be good potentially from an analytical point of view, from a diagnostic point of view, but it's not necessarily good at the Thomas Kuhn moments of actually branching out and leapfrogging and joining things that shouldn't be joined. So human beings relying upon that creativity, I think, is something that we somehow need to hang onto as we move through this uncertain future. One of the things we're really proud of at Curtin Law School is our focus on information governance. I won't go through all of the colleagues around the room that have a focus on information governance, but I will provide an opportunity for colleagues within the law school to pass some reflections upon what's been said. But I did want to give special attention to Dr. Nikos Koutros because this event was his brainchild and was very much based on the preformed relationship between him and Professor Joshua Fairfield. So just wanted to honour you, Nikos, by spawning this event and just give you the opportunity to reflect upon what you've heard so far. And I'm then going to pass it on to John Southland, who's got some reflections that he'll explain, and I'll move around the table accordingly and we'll just take it from there.
Yeah, thanks a lot once again. I'd like to, before I reflect on what has been already mentioned, which was really valuable, really important for for a list of reasons. I'd like to thank you, Robert. Thank you, Professor Fairfield, just for being here. Information Commissioner for Lina, for your help. Sareen as well, and all of you that you have devote some time and you are here to honor us in this round table discussion. I need to confess that I have the privilege and the exclusivity to accommodate Josh. So that means that since the day he's in Perth, we are ongoing a daily workshop of discussion. So I always try to capture whatever I can from his brilliant background of knowledge and being in this area of research field that I'm recently became part of. I like to be more optimistic, like the Information Commission. My motto is the Latin phrase "dum spero spero," so I will never lose my hope. And regardless of what we have already witnessed in terms of AI, and Robert, yes, I was also felt quite bad when I realized that that's not the proper question. After the discussion, the initial discussion.
Already unasked.
So yes, I'm on your side. I'm on your side. But I really want to keep that. Yes, the greatest core of all this out of this is that AI is committed to a specific task, whereas has nothing to do and is not fully aware of the welfare. And I think that autonomous weapons is an example of that. For example, and which is quite current, it's contemporary as well. But the thing is that I got freaked, to be honest, when yesterday Josh disclosed this thought that he holds about the human technology and now the technology human approach that we are witnessing. And then we had a discussion about the Terminator movie about this, because I said, okay, all these Hollywood movies do not come out of the blue. They rely on something, on data. There are sources outside there that they are, of course, it's inspiration. That's going to be intellectual, let's say, creativity. But on the other hand, if you just take this creation, then you start wondering about what exactly was hidden. But I don't want to further reflect on that. I really want to keep. I'd like to go to. Sorry for that, Josh. I'd like to go to the Information Commissioner's side in a way that let's keep it a little bit more positive. Let's try to benefit from that. Let's, of course, yes, regulate in order to put some borders and say some limitations and some restrictions. Otherwise, it's going to be definitely quite devastating for all of us. But I think that I better not reflect further, because, as I said, I have the exclusivity to have Josh with us. Hope that you have enjoyed the accommodation, by the way. I want that to be recorded. So once again, thank you for this brilliant discussion. And another thing that I'd like to address is that we have already been engaged with a lot of projects with Josh around AI, and I'm working on another one. By the way, I'd like to inform the Information Commissioner that I'm going to shortly send something for publication, and I'm proposing an AI Act for Australia. I know it sounds really big, and I know that if someone follows up me and see what I'm leading and the question of this, and then I'm about to propose an AI Act for Australia, might get puzzled a little bit. What is he heading? So I'm more than happy to collaborate further with you in due course, if that is also something that can be feasible. Again, thanks to everybody else, Josh, Robert, Pina, everyone else, and all those that they attend. And I'd like to, the floor is yours, John. So there you go. Thanks a lot.
Thanks so much, Nikos. So I think, just to respond to you, Nikos, I think we can walk and chew gum at the same time, as the US folk often like to say. So we can lament the dark, but we can also light the candles. And so let's do that over the next half an hour or so. John.
Thanks very much, Robert. I guess I'll give a tool of how to light a candle. There's been a lot of attention on corporations. And certainly I agree there's a need for regulation, whether it's new or old regulation being retooled. But one thing I'd like to point out is there are these standards. I often do this ad. There's these standards called the OECD Guidelines for Multinational Enterprises. 51 countries, including Australia, have signed up to these, and the government say these are expectations of business. One of the chapters is on science, technology and information. And essentially it gets to the question a little bit, which has been framed about how do we trust a machine or a process if it doesn't also understand the impacts of it. And this says of business, you should be doing a risk-based due diligence, not a due diligence of what works for you, a due diligence of your operations and your supply chains. And if there are impacts on humans in what you do, you need to do something to address that. And so and this has relevance then for, essentially it will say, you can't just, if you can set up a system where you can get a benefit, whether it's subsidiaries or however or contracts, however you want to do that, if you're able to get a benefit through some income or something, you also have some responsibility. And the same thing I think would apply to in the IT space. If you're setting up a program, if you're putting up a social media thing that you're able to update or you're able to get to that data, you can't then just say, oh, sorry, we didn't know that was going to happen with that. We don't have a responsibility for what's going to happen with that. So I'll leave it at that. Happy to answer any further questions. Thanks, Robert.
Thank you so much, John. So look, I'm going to open it up to the floor, but before I do so, Joshua, do you have any further reflections based on where the conversation has gone since your 30 minutes expired? This is sort of another right to reply. You get an extension.
That's right, I got a surreply here. Just briefly, if you want array of hope. And one thing to do is just play with the technology. You'll get this eerie sensation that your world has changed. I mean, it's just amazing. The question is not the technology. That's not the problem. The problem is our social technology, our social systems. And these OECD guidelines didn't stop Google's business model, didn't stop and doesn't constrain Twitter from dismantling and contributing to the worldwide democratic recession. I come from a pessimistic perspective on the regulation of companies, not on technology. And that is a product of my context, which is grounded within the US tradition, where we can summarize our regulation of companies by saying we've tried nothing and we're out of ideas.
So one of the things that I've played around with in my research is the notion of separation of economic power. So drawing upon the liberal economic democratic concept of separating power within constitutions, which of course flows from people like Montesquieu back in the 1700s. But as power has shifted from the political to the economic, we haven't necessarily come up with constitutional mechanisms to separate economic power. And so the multinational corporation has continued to flourish since the New Jersey initiatives back in about 1888 through to 1895, say, which essentially allowed one company to own another. I guess we could conceptualize that as a type of technology in a way, but what that did was allow for the concentration of economic power. But as I said, we haven't necessarily developed the constitutional mechanisms to deal with that separation. So while it's very useful to continue to separate legislative, executive and judicial power, if the power is not residing in the political, then how do we go about constitutionalising that separation of economic power? And I think there's ways and means in which we might conceptualise competition law, intellectual property law, perhaps even the law of privacy, through a constitutional lens. And I think that's where we could rely upon legal principles that have been developed for many centuries to give us hope for the future. It's not as though we need to go searching into the future for legal principles. Many of them are there. They're waiting for us. It's just that we need to enact them. And often these principles are just that, they're principles, but in order to make them real, it involves dealing with the democratic deficit and other political economic systems that we've developed. So with those further reflections, any other thoughts, comments, questions that you would like to ask? I'll pass it over to Thomas Fitzgerald. I think we're going to use this might be better than that one. Just swap ones for a moment.
Immediately got technology problems, which is so I guess
so just maybe introduce yourself too.
well, my name's Thomas Fitzgerald. I have worked in law and technology for a long time. I've actually been working on and off on law and AI for about 20 years. So I guess my great frustration with law and AI is that ever since the days of Professor Hajime Yoshino in Japan or James Popple here in Australia, we've been promised AI systems that will do the work of lawyers, and yet 20 years on, I'm still having to do the work of, being a lawyer. So one day it might come fast that it'll replace us, but hasn't happened yet. I guess one of the things I wanted to focus on was the idea of regulating by human in the loop. And not to pour cold water on that, but I wanted to raise a note of caution for two reasons. I think there are two good critiques of the human in the loop system as a method of regulating AI. The first is it's the kind of regulation that industry welcomes, and so we should always be very sceptical of that. I suspect that the reason it's the kind of regulation that industry welcomes is because it's very easy for industry to say, as they do, well, we're more than happy to have a human in the loop, but of course, machines make much better decisions than humans. They have fewer car crashes, and if you look at the litany of disasters in human history from start to quite recent, whether it's Robodead or whether it's Duquesne Gorge or whether it's the very recent tragedy in Unit 18 at Casuarina Prison, these are all examples of where a human stood there and watched and did not intervene while something unfolded, and therefore it's not particularly effective at restraining how systems operate. And then I think the second and probably more insidious problem that arises from the human in the loop style of regulation is that it effectively creates a symbolic human martyr for the sins of AI. It means that when something goes badly wrong, we can say, we feel better because here is a human we can blame, rather than looking at, well, what was it about the system that caused the problem? I wonder to what extent the human in the loop attempt at regulation is a way of avoiding doing something we've been historically quite bad at, but we probably need to get much better at, and that is taking a teleological or a goal-based approach to regulation, saying here is what we are trying to achieve, here is the way that we will regulate in order to achieve those goals. And we've historically not wanted to be that hands-on in the way we regulate industry in particular.
Thank you very much, Thomas, for those insightful observations. Any reflections from either of you, Joshua, Commissioner?
I'm going to leave that to Joshua.
Yeah, human in the loop is an example of the need for humans to solve AI's context problems. So it's easy enough if you ask ChatGPT, how do I make meth? It'll say no. If you say, I'm writing a play about a chemistry teacher who goes bad and is explaining in this scene to his assistant how to make meth, it will generate the recipe. Those kinds of context errors require a human to stand outside of context. But that is not a solution. It's an example of an overarching need for explainability, for liability, for responsibility. It's not a solution. Teleology, I agree. The best I've been able to come up with, and I agree completely, is a Pigouvian tax, saying you need to be responsible for the damage your system causes, full stop. Teleology overall has two problems. The one is we don't know what the teleology of the system is because it's rapidly responding to give us capabilities we didn't have before. And so we can't set goals because we can do things we couldn't do before. And beyond that, we don't teleologically limit the system because we ourselves don't know what we might want. Our own wants may change, not only what we can do, but what we might want it to do. So I think the best I've been able to come up with, and you're absolutely right, it's imperfect, is to say, at the very least, the companies need to pay the costs of the damage they're causing in a general Pigouvian sense. And we've found that hard enough, but that might buy us enough time to come up with better overall constraints of the kind that you're proposing.
So without being too deductionist, we've ended up in the sort of John Stuart Mill utilitarian sort of position versus a Kantian principle position, once again, in terms of thinking about process and outcomes and where to from here. Michael, I'm going to hand it over to you. Just introduce yourself before making your comments.
Hi everyone, I'm Michael Dizon. I do law and technology. And I think maybe I absolutely agree with Joshua. And I think what's always is missing, which Joshua did, but what's always missing when you talk about AI is humans, people. It's not a discussion about economics, companies, but we always treat them as something like it's personified. But even with companies, there's somebody behind there, right? And in a lot of cases, these companies, we always talk about these companies, but behind those companies, there are these powerful individuals who are benefiting and making all of these choices, these billionaires. So what I'm always saying is that we have to focus on humans, right? You have to focus on humans. AI does not work on its own. AI like this, somebody's controlling it. So the key there is who is in control, who has the technology, who owns it, who developed. We need to control those people and who are affected. So I always say, so to use as the mechanical Turk, right? The mechanical Turk, well-known thing that could answer things. There was a person inside the mechanical Turk. AI, there is a person. Where there's a company, there's a person behind that person, that system. So the key, I think, this important is always look at the human behind and the human affected. If people start talking about these things, and you've seen it in the language, it's as if the AI is more human than those who are affected. You'll see it. People say, "Oh, AI wrote this thing." No. AI is a tool. Somebody created that tool. We either regulate the person who creates it, or we regulate how people are affected by that tool. So I would personally prefer a human-centered, social values and norms-based approach. Because I don't like ethics, because ethics it tends to be very Western, very intellectualized, very obtuse form of regulation. I like social norms and values because that impacts people, right? Ethics is so intellectualized, it's very theoretical, but social norms, social impact, that's more important. So at least so long as we put the person, a real person in our discussions, then as Josh was saying, it's better grounded because you put a human in the loop, or it becomes human-centered. I would say that. It's a human-centered discussion.
Thank you so much, Michael. Any other questions, comments? Cheryl? Again, just introduce yourself, Cheryl.
Hi, I'm Cheryl Fong. I'm a senior lecturer here at the law school. I should preface this by saying I'm not a patent lawyer and I don't specialize in AI research. And usually I look at copyright. But I did have a few reflections and I'd be keen to hear your thoughts on them. They're quite IP-centric. And also thanks for the big picture approach. I really enjoyed that. And I think, it's something that we really need to keep our minds on as lawyers, as opposed to, getting to the niche questions. Just reflections on what you said about how, one thing that Robert said actually in reflection, you said, we're kind of, with the AI Inventor process, we're moving away from science as a process, it seems, and more focus, I'm paraphrasing, on the outcome of the AI producing something, useful. And it makes me think about the patent system and the initial rationale for having it, and the registration system, having this quid pro quo, public disclosure of how the invention works, and it seems that if you go towards that approach of focusing on the outcome and not the process or the learning process of human beings, and you might ask, is it possible to have that level of public disclosure from AI inventions, right? That's one question that came up in my mind, not that I thought about it in depth. The other issue that came up, I think, was when you mentioned, it's not necessarily a question of, we're asking the wrong question, right? And you said ultimately they'll get protected in some form, expropriated or something, perhaps copyright licensing. Or the alternative, maybe sort of trade secrets or something like that. But I think ultimately it's a question of, there is still a real question of how is it going to be protected, right? Under which system? And it still matters, I suppose. Even though we say we're asking the wrong question, the same question is always going to come up. So you can reframe the question, but they're still going to be asking the same questions in these kind of legal disputes. And it also makes me think of copyright. So copyright, for example, at the juncture of software, how should it be protected? Should it be protected as copyright or something else sui generis? And I do think that if it had fallen in a different way, if we had different system for protecting software, we might be in a very different place right now. So yeah, I guess my comment is that it's the wrong question, but it'll still be asked, and it will still have an influence on what system of protection, ends up protecting these kinds of outputs.
Before I ask if you've got any particular reflections, Joshua, I guess I'd just make the point that with Cheryl and others in the room being intellectual property scholars, it is an interesting domain in which to flesh out the tension between private and public interests, because that's what intellectual property has always sought to do since the protection of mirror making back in Venice in the 1500s. It's always about how do you incentivize on the one hand, but how do you also make those inventions for the benefit of others, or we could talk about creativity in a similar light. But as Joshua indicated along the way, AI doesn't need to eat. So the incentivization arguments break down. Now, by the way, they break down anyway, much of the time. But there are some exceptions, and although I'm not necessarily an apologist for big pharma, you can quite easily understand some incentivization arguments when there's big capital involved in invention. Not to say that the IP system is the only way of incentivizing. In fact, there's many ways of incentivizing creativity and innovation. But any particular reflections in relation to Cheryl's observations?
Yeah, briefly. I think the eating part is pretty key. The software was weird to regulate it like we would regulate the writing of a poem. But a human wrote the poem, and a human wrote the software, and a human needs to eat. There is an out-of-context problem with respect to the output of AI being plugged into the IP system at all. Let's start with the thought experiment. It exists, and we have not yet provided worldwide intellectual property protection for it. There's no reason to provide intellectual property protection at all if we want it to exist. Now, we might think it attracted capital because it made a bet that it was going to be able to leverage present intellectual property regimes into some sort of constructive control over the outputs. Legitimate, but it's an interesting place to start the entire question. Why should we give it any more intellectual property protection than we give the output of ocean waves? Certainly not to get it to produce. The incentive structure isn't the same. So I think these questions will come up, but they're questions of public and private power, and they're questions of distribution of productivity. And to the extent that they are actual intellectual property concerns, I think our eye should be very much on the ball of all of the humans whose photographs and art have been used as the input to these systems and who are not being compensated. Transaction costs often hide expropriation. So it was too expensive to track everyone all the time until Google and Meta came along and did it. And what we mistook for civil liberties were in fact transaction costs. It was just too costly to surveil us all the time. Similarly, it was too costly to extract everyone's labor, reprocess it, and then provide an output. We changed that through technology. We just don't have a framework for dealing with that shift in transaction costs. And so to me, and this is just purely my own opinion, I do think these questions will come up. I do think we will see repeated attempts to fit non-human authors under various intellectual property regimes. I maintain, and this is my personal view, that those are all the wrong questions, not just this question, it's all of them are the wrong question because AI doesn't need to eat and we don't need to incentivize it in the way that we've traditionally incentivized intellectual property output. Like ChatGPT charges me $20 a month, they're doing fine.
Thank you so much. So this idea of expropriation, I think, is a really interesting one. And I guess what capitalism is quite good at is privatising the benefits and socialising the costs. As we move into surveillance capitalism, the transaction cost story that you mentioned, it opens up new markets. As Demsetz, the law and economist, he would say that from a cost-benefit analysis, you will only create a market when the benefit of creating the market outweighs the cost. So it's the classic cost-benefit analysis, but that cost-benefit analysis applies to the creation of markets as well, which is an interesting observation from Demsetz. I guess the other reflection is that if we think about computer software and where it fits into the IP system, it's essentially code is language. And what I often say to students is that if you think about the English language, or in fact any of the other thousands of languages that have been developed since the beginning of human history, those languages weren't created because of a strong intellectual property system. Now, people didn't get out of bed in the morning and start speaking to one another or communicating with one another because there was a strong IP system. People want to share, people want to cooperate, people want to communicate. But then often those sharing dynamics get leveraged in the same way that I talked about share writing and Uber before, where something actually gets appropriated or expropriated, as the case might be. And this concept of language is very critical, I think, the protection and the creation of language, because after all, the generative AI systems are essentially just language models. Perhaps that's oversimplifying, but it's a big part of this. It's a big part of the story. Any other comments, questions before we move into great, Jenny, thank you. And just introduce yourself.
Yep. Hi, my name's Jenny Kiss. I'm a legal consultant. I've previously worked in-house in a number of different corporations. And so there were a couple of things I was reflecting on as you three have been talking. Well, everyone's been speaking. And one is that the common theme that we're concerned about with the application of AI is the damage to humans, whether it's a personal damage, economic damage, some other damage. And in Australia, I think after 40 years of legal practice, I'm forming a view that our law, our current legal system doesn't protect humans. It is driven, a lot of it, there's heaps of laws, there's thousands of them, and so you would think it would protect humans, but actually there's no Human Rights Act in Australia. Only some states have it. Treaties are still like a long way off, but constitutional issues are still unclear. We haven't actually said, okay, front and centre, we need to protect humans. One way we could do it is actually introduce the treaties that we've signed up to, which are, we have a lot of United Nations treaties for rights of Indigenous peoples and protection of cruelty to children. And, there's so many that we have as law, which we have to use really obtuse means to implement and argue that they protect us. So if we could do something to actually implement all the treaties we were currently signed up to, we would already have a body of law that could be used to argue in a situation where there's damage from AI. And just two other quick points. One was that Indigenous people have now Indigenous cultural intellectual property rights. So I don't know if you've seen some of the publications in Australia on that. That's actually some of the thinking that's useful in this space, I think, as a parallel. And also, a corporation, we actually just tend to think of it as a person now because we have, it was just a bundle of rights, it was artificial construct. I don't think we should have them anymore. What's the point? They should be just people. Just call them people, and we expect them to behave properly, not pollute the atmosphere, not breach all of these things. And if you pass more laws to protect humans, then the corporations will become less of a concern. Anyway, that's my couple of ideas. Thank you.
Thank you so much, Jenny Kiss. And I'm going to invite Sean Goltz to say a few words, and then chance for one more question or comment, and then we might break into some eating and drinking.
Thank you very much, Robert, and thank you, Joshua. So first off, I wanted to mention that this is kind of a déjà vu for me because when I was writing my PhD on virtual worlds, I was reading Joshua's papers, and even before that, when I wrote my master's on video games, I was reading Joshua's paper, and then I worked with Nikos at ECU, and I worked with Michael at Waikato. I didn't even know that he's here, so it's quite funny. So I basically wear two hats in this realm. So I'm an academic, and I'm researching AI ethics, and I'm also engaged in what I would call simply data trading. And that allows me to have a first-hand experience of what is now going on. And I would think we should say that it's not necessarily the AI revolution, but actually the data revolution. Just to give you a taste, there's currently around 20 data marketplace working, and they all seems to be doing quite well. So data has become a very expensive commodity. I strongly agree with Joshua that technology is not neutral. I would go to Jacques Ellul's The Technique Society, and unfortunately, every time that I talk about this question with my students, they're all of the opinion that it's like a gun. It depends what you do with it, it depends on the user. However, I agree 100% with Joshua that it doesn't care about our welfare, and even beyond that. So that's one thing. With respect to the prophecies of the danger, I think that one thing we should be very mindful of, especially from the context of law, is AI hallucinations. So most of you are probably familiar with the case of Avianca, where the lawyer has submitted to the court around 6 fake cases created by ChatGPT, and then when he came back to ChatGPT to verify, ChatGPT actually wrote an entire decision, and I was privileged enough to read the decision that ChatGPT wrote, and I bet you that most of you, if not all of you, would not have identified that this is the work of an AI rather than a human or a judge. Although there are some, discrepancies and nonsense in that decision. So my thoughts around this and what I'm trying to now work towards in terms of identifying and preventing those hallucinations, especially when it comes to law, is that, and I agree with Joshua on that, the process of the danger from AI is much more nuanced and hidden than what we think. It's not about the toasters coming up on us, but rather imagine if a case like Avianca, and who knows if there are cases like that, would have go forward. Those cases that were fake, would have included in the judgment, would have later been cited by lawyers. And that's just case law. Imagine what would happen with laws. And also, I think it gives proportions when you think about the size. So global regulation is a search engine of laws from around the world, covering around laws from around 100 countries. It's around 100 gigabytes. If you compare that to synthetic data, to receipts, to all this crap, so to speak, that is going out in the market, you realize that this very small and precious data is the infrastructure of our society, of our human society. And if we allow the machines and the corporations and so on and so forth to bypass this protection or guardrail, then I think we're in the deep trouble. So, yeah, thanks.
Thank you much. Yeah, please, Commissioner.
And I don't mean this to be the final word at all, but I just have been sort of listening with obviously great interest about all of the sort of ideas and the thoughts around protections and the importance of humans being involved in decision making or decisions about other humans. And I think perhaps one of the ideas for the law remaining flexible is to go back to the concept that's used a lot, certainly used a lot in the Freedom of Information Act, and that is, ultimately what's in the public interest. That's where I feel enormously privileged in my position, is that I'm often the last decision maker about where the public interest lies. And to entrust that type of decision to AI or a machine concerns me greatly. I'm very happy to be assisted by AI in computational issues. Give me a data set, that I can't spend the time, or somebody who's coming to me for a decision has utilised AI to present a summation of enormous data set or combine data sets to present some facts to me. But at the end of the day, providing the protections under my piece of legislation, or not mine, the Freedom of Information Act, to whether information is made available to the public or is kept secret, often the decision comes down to is it in the public interest or not to disclose? And that to me is the quintessential human decision because you need all the data sets in the world to arrive at that decision. My decisions aren't perfect, but they're the best I can make with the knowledge that I've got, drawing upon my life experience. And I think that's a really critical thing to sort of try and come back to, and that will provide, I think, the sort of underpinnings of this type of flexibility that the law needs in order to utilise AI in a way that is fair.
Thank you so much, Commissioner. And your reference to public trust makes me think of the public trust doctrine, which is an old doctrine that was used a lot in environmental law, but essentially prohibited the government from selling off things that were of a public nature. And if we think about how that notion of public trust might relate to the information environment that we occupy, I think it's interesting because it's been used, for instance, in relation to avoiding the privatisation of a lake, for example, so that people could move from A to B. But of course, information now has an infrastructure dimension, and it's a key piece of infrastructure in our liberal economic democracy. And so questions about who owns that infrastructure become increasingly important. I think we had a question or comment over here, and then I will seek to wrap up. But I'm going to invite people to say something to the camera
in my office, so we will have something to eat. But if you do want to say anything to the camera by way of reflecting upon today's event, then there's an invitation to go to my office, which I'll point you to in a minute, and you can just say a few sentences if you'd like. And I'm going to invite Joshua to do the same thing, so we'll see if that works out. Please introduce yourself.
I'd first like to thank Joshua for the hot investment tip that he's willing to gamble on. My name is Alex Gordon. I'm a solicitor. I work in litigation. So that makes me a worker and not an owner, as Joshua puts it. I'm not the information commissioner. I'm not a dean. I don't have an exciting exotic accent. So I need to be concerned about where my future is going. So forgive me if this question's self-serving, but how do you see the development of the practice of law and the role of a lawyer with the evolution of AI?
The succinct answer I borrowed from somebody else. I was at a conference panel from the Appellate Judges Education Institute, which is the National Appellate Judges Conference in Washington, D.C. last Friday. And the response is this: the practice of law will shift to the high end of the license, if all goes well. That is what we're going to end up doing, is most of our time thinking about what should be and how to get the law to create a new normative universe that's better for us, to evolve past questions that we should stop asking, like an old question might be under the scholastic tradition: how many angels dance on the head of a pin? We never answered that question. We moved to a new normative framework that asked a better one. Or Shoshana Zuboff: how many hours a week should a child work in a meatpacking factory? There's no answer to that question. We need a better normative universe that unasks that question and gives us a different framework. That will be the practice of law, generating new human frameworks of meaning that give better expression of our values in our lives. As far as the confidence that it's not going to be used in law, what's today? The 10th. I think in 5 days, Thomson Reuters launches CoCounsel, which is an AI specifically designed for legal use. And we will, and have already seen, the garbage in, garbage out problem. AI generated language will be then used as the texts that are read by AI. Under the common law system, we are particularly susceptible to a loop infection. And I believe the only solution is what the commissioner said: grounding in human experience. That's the only ground on which we can actually answer that. So in that way, choosing what cases are brought, what advances human welfare, what changes the world for human beings, the high end of the license. That's what we're going to be doing.
Any confidence in the future, Alex, after that?
Well, I'm just hoping my investment comes up.
Maybe invest in open chat GBT, so-called. Look, there's much more that we could say, but it's now time, I think, for me to thank both speakers, Professor Joshua Fairfield and the Information Commissioner Catherine Fletcher, and to also once again thank Dr. Nikos Koutros for his incentivisation of this particular event, and also thanks to everyone that's turned up. Part of the story here was to join some dots and to bring good people like yourselves together to think about how we might advance initiatives and thinking in this space in the future. Of course, what we're talking about here is very much a global phenomenon, but if we take what we've been talking about seriously, which is the human dimensions, then there has to be a local dimension to this as well as a global dimension. And so I think here in Perth, we have as much right as anyone else, anywhere else, to develop our own thinking around how we want to interact with this technology. And of course, as Jenny indicated along the way, the law often serves particular interests. And as I often say to students, that's because the law's not handed down from heaven. It's created by human institutions, by us. And we sometimes forget that. We sometimes think that law is created elsewhere, and then we've got to pick up the pieces. But of course, one of my passions has been looking at the development of environmental law and thinking about how we might apply some of those principles to the information environment.
But of course, environmental law didn't come from a vacuum. It came from political movements, ecological movements and otherwise, that spawned laws to protect and maintain the physical world. And part of James Boyle's analysis, I guess, is that in the information environment we have a lot of fragmented interests, but if we can draw out the commonalities of those fragmented interests, then we will see that we have much more in common than we do apart. And it's only then that you really can make progress in terms of politically creating the laws that take the human-centred approach and embed the human values that we've been reflecting upon today. Thanks very much to the speakers.